I am Flavio Guberman, Senior Partner at Carrion Law Firm, Head of Corporate, Business and International Law Department in our firm. I am quite glad to have this opportunity to talk to you again. A modern challenge faced by every single democratic society on earth is a fair judicial system with a widespread access at a reasonable cost. However, no solution yet has been found to an appalling problem, time. In fact, the morosity of any judicial system is perceived as one of the most crucial issues companies and individuals are confronted to. Since, no matter in what country, any matter brought to a court will take an unreasonable time to be solved. And it's common sense that time is crucial and long delays may turn any rule or decision ineffective. Arbitration is perceived as an alternative, even in societies originally very refractory, such as Brazil. In the late 80s, the idea of an affordable and faster system gained in strength, and the very outdated arbitration system was deeply reformed. In 1996, the federal law of arbitration was approved, and since then, millions of arbitrations took place. Today, the Arbitration Act is under discussion again, and a wide range of modifications will occur, making arbitration even more attractive. We will present today an overview of conceptions under Brazilian law, how arbitration works in Brazil, and what will change once the reform is concluded. In Brazil, arbitration operates under the framework established by Law number 9307 of 1996, commonly known as the Brazilian Arbitration Act. Arbitration in Brazil is consensual, meaning parties must agree to resolve their disputes through arbitration. This agreement can be in the form of a clause in a contract or a separate agreement entered into after a dispute arises. Once parties agree to arbitration, they select arbitrators to resolve their dispute. The number of arbitrators is typically determined by the parties, but if they cannot agree, the default is usually 3 arbitrators. Arbitrators can be chosen based on their expertise in the subject matter of the dispute. The arbitration proceedings are conducted according to the rules agreed upon by the parties, or, in the absence of such agreement, according to the rules chosen by arbitrators. The proceedings are typically less formal and more flexible compared to traditional court proceedings. Parties have the opportunity to present evidence and arguments to the arbitrators, which may hold hearings where witnesses can testify and experts can provide opinions. The rules regarding evidence and hearings are determined by the parties or the arbitrators. Once the arbitrators have heard the evidence and arguments presented by both parties, they render a decision known as an arbitral award. This decision is final and binding on the parties, meaning they must abide by it, unless there are limited grounds for challenging the award under Brazilian law. Arbitral awards issued in Brazil are generally recognized and enforceable both domestically and internationally. The Brazilian Arbitration Act provides for the recognition and enforcement of arbitral awards in a manner similar to court judgments. Brazilian courts play a supportive role in arbitration by assisting with certain aspects of the process, such as the appointment of arbitrators, interim measures, and enforcement of awards. However, judicial intervention is generally limited to instances explicitly provided for in the Brazilian Arbitration Act. Overall, arbitration in Brazil provides parties with a flexible and efficient means of resolving their disputes outside of the traditional court system, with the support of a robust legal framework and judicial system. In 2015, the Brazilian Arbitration Act, Law number 9307 of 1996, underwent significant modifications with the enactment of Law number 13129 of 2015. Some of the key modifications introduced in 2015 include the amendments clarified and expanded the scope of interim measures available in arbitration proceedings. It empowered arbitrators to grant interim measures to preserve assets, protect evidence, or ensure the effectiveness of the arbitration process. The law clarified that disputes involving administrative contracts and those related to the public administration could be subject to arbitration, provided that the parties expressly agree to it. This helped to overcome previous uncertainties regarding the arbitrability of certain types of disputes. The amendments explicitly allowed third-party funding in arbitration proceedings, providing parties with more flexibility in financing their cases and potentially increasing access to justice. The modifications also reinforce the role of Brazilian courts in providing judicial support to arbitration proceedings. This includes assistance with the appointment of arbitrators, interim measures, and enforcement of awards. The amendments streamlined the procedure for the recognition and enforcement of arbitral awards, aligning it more closely with international standards and facilitating the enforcement of awards both domestically and internationally. The amendments reinforce the confidentiality of arbitration proceedings and awards, providing parties with greater assurance of privacy and discretion. One may say that the modifications introduced in 2015 aimed to modernize and enhance the Brazilian Arbitration Act, making arbitration a more attractive and efficient means of dispute resolution in Brazil, while ensuring compatibility with international best practices. After some time, a few other topics came into light, intending to reform, improve, update and modernize the Arbitration Act even further. There are some bills, Projeto de Lei 3293 of 2021, proposing changes to arbitration practice in Brazil, and this is under consideration in the Chamber of Deputies. Additionally, there is an action in the Supreme Federal Court questioning the criteria for the disclosure duty of arbitrators. There have been calls to streamline arbitration proceedings and enhance their efficiency. This includes measures to expedite the appointment of arbitrators, simplify procedural requirements, and reduce the time and costs associated with arbitration. The bills under discussion in the Congress also intend to clarify and expand the provisions regarding interim measures and emergency arbitrators. This would provide parties with more effective mechanisms to obtain urgent relief during the arbitration process. There also have been debates about the further regulation of third-party funding in arbitration, introduced in the 2015 reform. Third-party funding involves an external party financing one party's arbitration costs in exchange for a share of the potential award. Some argue for clearer rules regarding the use of third-party funding to promote transparency and fairness in arbitration proceedings. One very important point is the arbitrability of disputes involving public law issues, such as contracts with government entities or regulatory matters. Clarifying the arbitrability of such disputes could provide parties with more certainty and confidence in using arbitration to resolve a broader range of disputes. It's a very sensitive matter in Brazil, and to make arbitration a viable alternative, changes must be also introduced into the public procurement law, which is a very rigid and strict piece of legislation. Generally, disputes with public entities in Brazil are quite long and expensive, so arbitration may be a good alternative. But a new legal framework must come to light to provide contracting parties and those opting for arbitration with legal certainty, that any decision established in an arbitration award will not be annulled by subsequent judicial proceedings or by political ideological issues of later governments. While there hasn't been a comprehensive reform of the Brazilian Arbitration Act, these discussions and proposals indicate a growing recognition of the importance of arbitration as a means of resolving disputes in Brazil, and efforts to enhance its effectiveness and efficiency. Any future reforms would likely aim to address these issues and further strengthen Brazil's arbitration framework. Efforts have been made to promote awareness of arbitration and its benefits among businesses, legal practitioners, and the general public. This includes educational initiatives, conferences, and seminars aimed at disseminating knowledge about arbitration and encouraging its use as a dispute resolution mechanism. We, at Carrion Advogados, are quite prepared to assist you in all your needs, helping you in your case, preparing arbitration, and representing you, including acting as arbitrators. Since we have a qualified team of lawyers and accountants able to provide you a work of excellency, do not hesitate to contact us. We will be more than pleased to help you, and we are at your service to clarify any doubts and to answer any questions you may have on this and any other legal question.